Welcome, everyone. My name is David French. I'm a senior fellow at the National Review Institute, a senior writer at National Review, and I'm here to welcome you to the annual National Review Institute Pacific Legal Foundation SCOTUS preview event. So first, thank you all for coming. And let me just begin by addressing the 800-pound gorilla in the room and say that we are not going to be addressing the 800-pound gorilla in the room, which is we're not going to be talking about the events of yesterday, the events, what we anticipate to happen over the next 72 hours or 2 weeks or 3 months or next couple of years of politics of the Supreme Court. We are actually here to talk about Supreme Court cases, and we're here to talk about Supreme Court cases with the people who are actually arguing cases this term. So I appreciate very much your attendance, your interest, and I will say this, if you do want to talk about what's happening and what's going on, I'm happy to stay around afterwards and spread my punditry for whatever that is worth, not much. I'm watching it along with the rest of you guys, but I'm happy to field questions afterwards. But for now, we're going to turn to the formal part of the program. And after about 45 minutes or so, we're going to open up for questions. And I will hop back up here to direct that portion of the program. But for now, let me turn things over to Todd Gaziano, who's the Chief of Legal Policy and Strategic Research at the Pacific Legal Foundation, and also the director of a center I want a part of, the Center for Separation of Powers, an issue near and dear to my heart. Todd?
Thank you very much, David. We will definitely include you in the center. And as a courtesy to our speakers and to everyone, please silence your cell phone. So that's my first bit of advice. I also want to thank everyone on behalf of Pacific Legal Foundation and thank everyone at Jones Day for the use of this fantastic room, great staff assistants and technical assistants, and especially to Dana Clabbers, whose professionalism and courtesy is really unmatched. This is not the first of our annual events where we had the possibility of an 8-member Supreme Court, although we don't know how long that may be this term. But this is the first of our 5 events where 2 of our distinguished speakers are actually arguing the same case opposite of each other. But wisely, they've decided to reserve that argument for the Supreme Court. Although I think David is going to at least mention what the issue is that they will be arguing against. As a point of personal privilege, the Pacific Legal Foundation has already won 2 Supreme Court cases for its clients this calendar year, and we have 2 more cases on the docket for next week. I believe Paul is going to talk about one of them. But if anyone in the audience wants to ask a question about the other one, the Weyerhaeuser case, I hope David French will not rule the question out of order. After a very brief introduction, as I said, the speakers will talk about 3 cases each, including some that were granted cert just yesterday. We will then have probably another brief round where they can comment on each other's questions and talk about any cases that may be on the horizon. I'm going to be scandalously short and brief in the introductions that they deserve, or we wouldn't have time to hear them. But I will begin with Paul. Paul is a partner at Kirkland and Ellis. He was the 43rd Solicitor General of the United States. He has argued over 90 cases in the Supreme Court. His list of, I think, landmark cases is probably too long even to mention. But he was a law clerk to Justice Scalia in the 92-93 court term. David Frederick will speak next. He's a partner at Kellogg, Hansen, Todd, Figel, and Frederick. His distinguished government service includes 5 years in the Solicitor General's office as an assistant to the Solicitor General. He has argued 50 cases before the Supreme Court, including 2 so far that are on the court's docket for this term. I should add that I think Paul picked up one yesterday. David is also a distinguished and respected author on Supreme Court advocacy. His books include Supreme Court and Appellate Advocacy and The Art of Oral Advocacy. He clerked for Byron White in the 91-92 term of court the year before Paul. And last but certainly not least, Shay Dvoretzky is a partner here at Jones Day. Being relatively young, he has argued only, and I use that term facetiously, 7 cases so far, but he's already got 3 on the docket for this term, one of which he picked up yesterday. He's going to I think, at least talk about 2 of them in his summary. Shay also clerked for Justice Scalia on the Supreme Court in the 2001-2000 term. So with that, Paul, why don't we begin with you?
Sure. No, thank you, Todd. It's great to be here. And I'm going to talk about 3 cases and do so relatively quickly. So I'll start with one of the cases. This is a case that Pacific Legal Foundation is integrally involved in. This is the Nick case. And the issue in this case is whether a Supreme Court case called Williamson County will either be overruled by the Supreme Court or substantially cut back on, or whether it'll be reaffirmed. The Williamson County case, for those of you that aren't familiar with it, is a case that sort of sounds quite technical, but ends up being quite significant in terms of limiting the ability to bring takings cases in federal court. Because the Supreme Court in the Williamson County case said that if you have a claim for a takings based on something that the state has done to you and to your property, it's not really a completed violation until the state's not only taken your property, but denied you just compensation for the taking. And therefore, they suggested that you need to bring an inverse condemnation action or other action in state court to try to get just compensation before you go into federal court. And if that just meant that you had to sort of exhaust your state remedies first and then go to federal court, that would probably be one thing, but there's almost like a bait and switch in the case because the court tells you you have to first go to state court to exhaust your state court remedies, and then if that doesn't go so hot and you try to bring your action in federal court, then the federal courts come around and invoke another precedent called St. Remo and say, guess what? Collateral estoppel, you lose. So you never get your day in federal court. And this is something that I think a number of justices of the court have suggested in separate writings they think is something that needs to be reconsidered. And the Nick case gives the court a chance to reconsider this. It arises in an interesting context where the individual was told that there are actually grave sites on the property that they own, and that under state law that means that they have to allow both random visitors and the state itself onto the property, on an intermittent basis. And so that's what gives rise to the claim. But the real issue is this one about the future of the Williamson County case. I think this is a case that, maybe it sounds a little bit technical, and especially if you're not familiar with the Williamson County case, but I actually think it's quite an important case because the Williamson County case and this phenomenon of first you must exhaust and then you're collaterally estopped has really kept a lot of important takings issues out of the federal court system, generally with respect to constitutional rights, where the person that's alleged to take your constitutional rights away is the state government. We generally want there to be the possibility of a federal forum because there's some suspicion that the state courts that aren't as good at adjudicating claims of federal constitutional rights as federal courts might be, just when the state's own actions are on the line. There's a suggestion generally that getting to federal court is important, and yet that really has been denied in the context of takings cases. And it's, I think, one of the reasons why at least some of the justices feel like sort of takings claims have become sort of the weak sibling among constitutional rights protected by the Bill of Rights. So speaking of the Bill of Rights, another case that's up in the Supreme Court this term is a case called Timms. And the issue in the Timms case is whether the excessive fines clause of the Eighth Amendment has been incorporated against the states through the 14th Amendment. And you might think to yourself either, wow, that sounds technical, or if you thought about it a little bit, you'd say, are you kidding me? Are you telling me that the excessive fines clause hasn't been incorporated against the states, given that it's in the same clause of the Constitution as the cruel and unusual punishment clause, and the Supreme Court hears 2 or 3 cases applying the cruel and unusual punishment clause of the Eighth Amendment involving states every year? How in the world have we gotten to 2018 and the court hasn't squarely decided whether to incorporate the excessive fines clause. Well, I'm here to tell you that this is the term for it. I don't generally like to make predictions in Supreme Court cases, but I'm going to go out on a limb and say that the Supreme Court is going to recognize in this case that the excessive fines clause, like the cruel and unusual punishment clause, has in fact been incorporated against the states. There may be some interesting separate writings that ask whether the right way to incorporate the excessive fines clause is the privileges or immunities clause versus the due process clause, but I don't think there's really much doubt about the outcome in this case. I will say, just alluding to the possibility that there might be an 800-pound gorilla somewhere in the room that, I would think maybe after the last couple of weeks, the Supreme Court might be looking for some issues that they can all agree on. And I think this might be one of those cases where the court can all agree that the excessive fines clause should be incorporated against the states. I say that in part because if you look at the amici that have filed in support of incorporating the excessive fines clause, it is a very big tent. You have conservative groups that want the excessive fines clause to be incorporated because they think that it's sort of for similar reasons to takings concerns and civil forfeiture. They think excessive fines clause will cut back on that. You have groups like the ACLU and the NAACP who are legitimately very concerned about some local government practices where you start with a $25 fine, and if you can't pay that, the fines sort of accumulate so quickly that pretty much you owe everything you've ever had to your local government. And then you have the Chamber of Commerce filing in support because they're concerned about excessive fines against corporate entities. So I really do think it's sort of an important case, but it's an important case, I think, in confirming something that I think most people would have suspected, which is that the excessive fines clause is incorporated. And so I will just finish up my presentation. I want to make sure I cover everything I'm supposed to by mentioning the Frank case involving something called the Cypre doctrine. The Cypre doctrine, I may or may not be saying it correctly, but I don't think you can really 100% correct my pronunciation because it's actually a phrase from the Middle French, I'm told, and I'm just not sure anybody quite knows how to pronounce Middle French. The doctrine, roughly means in English as close as possible, and it's a doctrine that goes back to trust law, and it tries to encapsulate this idea that sometimes you would have a trust that was set up for a purpose that can no longer be actually accomplished. So if you imagine kind of the example I like, if you put together a trust where what you really wanted to do is repeal the 18th Amendment, and here I'm setting up your case, but if you really wanted to repeal the 18th Amendment and you put all your money in a trust to do that, and then the 21st Amendment comes along and it does what you put all your money to, but you still got a bunch of money in the trust, they have to modify the trust to do something that's as close as possible to that. So who knows? Maybe it ends up going to Mothers Against Drunk Driving or something, but or the opposite. I don't know. But the point is, you try to reform the trust in a way to try to capture the intent as close as possible. So what does this have to do with kind of anything? It actually has a lot to do with class action abuses, because this doctrine was first used when you had a class action that gave lots of people who settled a certain amount of money, and some small percentage of them didn't show up at the end to collect their money. And so you have a residual in the sort of account that was put together for damages. And what do you do with the residual? You give it to some worthy charity. Well, somebody along the way got the idea that we could essentially cut out the part where you actually give class members some money themselves and there's just a residual, and jump right to the residual. So what happened in some class action settlements is they basically said, there's no money for the class, but we're going to have like some amount of money, say $10 million or whatever, that will go to charities. And then the class will settle, and there'll be charities that kind of are trying to do things that might benefit the class. And there's a lot of amorphousness to that, but the class really isn't going to get anything. Now, you could ask yourself, why in the world do those kind of settlements make any sense? Well, they make a lot of sense for the only two people who are in the room at the time of the settlement, namely the class action plaintiff's lawyers and the defendant that's facing a class action suit. Because the defendant can get the suit to sort of go away and settle the class action against the entire class, and the plaintiff lawyers who want to get paid a percentage of something, And by giving $10 million to charity, that gives a nice number that you can get a percentage of if you're the class action plaintiff's lawyers. But from the standpoint of the class, gosh, something seems wrong about this. And so this is an issue where the Supreme Court will tee that issue up. The Chief Justice of the United States kind of teed this issue up in a separate opinion a couple of years ago, where he suggested that this practice needed reconsideration. The court will give reconsideration this term. I think the hard question will be, what part of Rule 23 and the text of Rule 23 does the court sort of put and attach its skepticism of these kind of settlements to? I think the logical place is some of the language in Rule 23E about the approval of class action settlements.
Very good. And you're on time. David.
Thank you very much. It's a pleasure to be here. The first case that I'm going to talk about is a case called Gundy versus United States. This is a case involving the non-delegation doctrine, a doctrine that was famous back in the New Deal era in a case called Panama Refining, where the court held that if Congress did not set specifically appropriate standards for delegating authority to executive branch officials who were charged with providing law violations for private actors, that delegation would not be appropriate under the Constitution. In this case involves whether or not Congress violated the delegation doctrine, the non-delegation doctrine, in a case, a statute involving a sexual offender registration. This act, popularly known as SORNA for Sexual Offender Registration National Act, I think is the way it is done as an acronym, was enacted at a time when Congress couldn't quite figure out and resolve all the various political disputes that it had before it as to whether or not it would apply retroactively to sex offenders who had been convicted prior to the enactment of the legislation, how states were going to be designing their databases, and the like. So Congress did what Congress often does, which is not decide the question, but punt it to the executive branch. And they enacted a provision that gave the Attorney General the authority to promulgate regulations and rules to determine whether or not this act was going to apply retroactively to sex offenders who had their main convictions occurring before the enactment of SORNA. So along comes Mr. Gundy, who is a previous sex offender. He moves from one state to another and is prosecuted for having not kept his sexual offense registration up to date in New York when he moves from Pennsylvania to New York. He's prosecuted, he's convicted, and the question before the Supreme Court is whether or not his violation of the Attorney General's regulation runs afoul of the non-delegation doctrine. The government says that there should be implied in the delegation a feasibility standard, which is that the Attorney General has the authority to determine whether or not there's a law violator for the previous conviction, so long as it's feasible for the Attorney General to do that. Mr. Gundy argues that that's basically standardless and it gives such wide discretion to the Attorney General that it functionally is no standard at all, and therefore runs afoul of the Panama Refining Principle, which struck down the National Industrial Recovery Act provision that empowered the executive branch to decide whether the transshipment of oil from one state to the other exceeded certain limits. And the Supreme Court in 1935 had held that where there wasn't an appropriate standard conferred by legislation, the Constitution would preclude the executive branch from exercising the authority to criminalize that private behavior. So we are sort of back in the New Deal era to some degree in the way that the Gundy case is being argued and likely will be decided. The second case is a case that Paul's very familiar with. It's a case called Franchise Tax Board versus Hyatt. This case has been up to the Supreme Court now the third time on the merits. Paul argued the second time on the merits, but not the first time, if I recall. This case involves a decades-long dispute between Gil Hyatt, a patent owner who has received a royalty stream for his invention, and the California Taxing Authority. Back in the early 90s, Mr. Hyatt moved from California to Nevada in part to minimize his tax burden under state income tax rules. A dispute arose between himself and California as to when the effective date of his move was. This had pretty substantial effect on what his tax liability was. So thereupon ensues a very long litigation saga between Mr. Hyatt and the California Franchise Tax Board that, as I say, has bounced up to the Supreme Court, back, up to the Supreme Court again, down, and now back up to the Supreme Court. And I will give you the 1-minute version rather than the 4-hour version of the actual litigation procedures involved in the case. What's before the court now is whether a 1979 precedent known as Nevada versus Hall should be overruled. The question in Nevada versus Hall was whether a state could be sued by the citizens of a state in a different state's court. In Nevada versus Hall, it was a Nevada resident suing the state of Nevada, but in a California state court for a tort that was committed by a Nevada official government person. In this case, the question is whether the California tax people who are alleged and were found by a jury to have committed torts against Mr. Hyatt in the auditing and in the advertising of the California tax rules could be sued by Mr. Hyatt in Nevada state court. The original jury verdict went into the hundreds of millions of dollars. That has subsequently been remitted by various appellate decisions. And what is left of the case now is a $100,000 judgment that the Nevada Supreme Court upheld against the California Franchise Tax Board. California's tax board has petitioned for cert asking that Nevada versus Hall be overruled so that it would be immune from suit. And it raises some fascinating questions, to me, fascinating questions about the origins and founding of the Constitution, because on the one hand, you have an argument that prior to the promulgation of the Constitution, question of whether or not states were truly sovereign in the sense of being able to deny litigation that would be brought against them in other state courts, versus the way that the 11th Amendment came into the Constitution in questions of state sovereignty that have been deemed to be quite expansive immunities from suit under structural provisions of the Constitution and emanations, if you will, of the 11th Amendment's text. So I think as Paul has gone out boldly to say that he thinks that the excessive fines clause will be incorporated as against the states, I think that the betting money would be on California Franchise Tax Board that Nevada versus Hall seems to me to be in danger. The court split on that question 4-4 the last time the case was before the court, and they granted cert again on the basis of a fairly modest judgment against the state. The third case that I'll talk about is a case called Thacker versus Tennessee Valley Authority. This case was granted yesterday, and it also involves another New Deal program, the Tennessee Valley Authority. That program, as you probably are all aware, led to the electrification of Tennessee and the creation of a dam project that has been very important in that region's development. When Congress created the TVA, it had in the Organic Act of the TVA a sue and be sued clause that would confer power on the TVA to sue wrongdoers and to be sued if in the event that it engaged or its officials engaged in wrongdoing. This particular tragic accident involving the Thackers and another person was involved, kind of the most mundane of circumstances at one level. There was a fishing tournament. They were out in a fishing boat. They were going rapidly in a fishing boat to go, I guess, from one fishing hole to another. And the officials for the TVA were working on a line, a power line that had fallen and kind of was lax. and they were pulling it up out of the water with a conductor that had been running power through it. And at the very moment the boat comes by, the power line gets up, the folks in the boat get electrocuted, and one of them dies. And the question is whether or not their suit against the TVA can proceed in the face under the sue and be sued clause, or whether the TVA can invoke what is known as the discretionary function exemption, which is done specifically by statute under the Federal Tort Claims Act, but is not expressly provided in TVA's Organic Act. The government is defending the suit on the ground that a discretionary function exemption is implied in the TVA's Organic Act, notwithstanding the sue and be sued clause. Shay and I are going to be arguing a case probably in January, although the court hasn't set the calendar yet, called Merck versus Albrecht. This is a case involving preemption principles under the Food and Drug and Cosmetic Act. I think that's about all I'll say about it, unless you want to say more, Shay.
Did you want to mention your second case just what
Well,
it is?
I'm arguing BNSF versus Luce, a case that I'm sure you will all be riveted involving the railroad retirement tax. Stay tuned for this one, November 6th, Election Day. Instead of focusing on the elections, I think everybody here ought to be focusing on that case. And then I'll be arguing Apple versus Pepper, a case involving the Illinois BRIC rule for whether consumers have standing to sue Apple for its iPhone monopoly on apps.
Oh, that's right. Thanks.
Thank you.
I missed one. And Paul picked up one yesterday, but involuntarily you were a respondent trying to oppose cert. But you will
Thanks
be-
for mentioning that,
you
Todd.
will be
That's great. Thank you.
back nevertheless. But he can mention that in his second round. Shay?
Thanks, Todd. I agree with everything David said about Merck. We'll see how long that agreement lasts, but for now we're on the same page. The first case I'll talk about is Gamble versus United States. And the question presented in this case is whether the court should overrule the separate sovereigns exception to the double jeopardy clause. The exception dates back to the 1920s, and it allows separate sovereigns, typically the federal government and the state government, to prosecute the same individual for the same offense. That's what happened in this case. The petitioner, Mr. Gamble, was twice convicted and twice sentenced for the single crime of being a felon in possession. This case was relisted a number of times in the spring before the court ultimately granted cert. So it seems like there were some machinations going on behind the scenes about what to do with this. Justice Ginsburg and Justice Thomas had previously written separately that they would support overruling the separate sovereigns exception. The Justice Gorsuch seems like he would also be sympathetic to the same argument. The basic argument for overruling it combines both originalism principles and also basic fairness. As an originalist matter, at the time of the founding and well before, English courts did apply double jeopardy principles to separate prosecutions. And so if you were prosecuted for a crime in France, you couldn't be prosecuted for the same crime in England. The text of the double jeopardy clause doesn't admit of any exceptions for separate sovereigns. And then obviously there are fairness concerns to these sorts of double prosecutions. Under the exception, somebody could be acquitted in federal court of a particular crime and then sentenced to death in state court in a subsequent prosecution for the exact same crime. A few other interesting aspects of this case, I think. One, the government hasn't filed its brief yet, so we don't know what the government's going to argue. Presumably, the government will have to appeal to stare decisis principles. Stare decisis is obviously a touchy subject these days, given a number of potential precedents that parties in different contexts are asking the court to overrule. So it'll be interesting to see how that plays out in the context of this particular case, which I think has the potential to bring together different wings of the court, so to speak. Justice Thomas and Justice Gorsuch, for example, may very well be concerned with the sorts of originalist arguments that I mentioned. Justice Ginsburg and Justice Sotomayor may very well be concerned with the sorts of fairness arguments that I identified. And so it'll be interesting to see how all of that is reconciled in the context of a debate also about stare decisis. Somewhat surprisingly, this issue actually doesn't come up all that often. Usually, I think federal and state prosecutors do try to coordinate, and even if they don't, given the number of different criminal laws on the books these days, it's often possible to prosecute an individual for what seems like the same offense, but under different statutes that have slightly different elements. And that would be the case regardless of the separate sovereigns exception. Another potentially interesting practical consequence of this, the government may bring this up in their brief. One practical justification for the doctrine is that there have been some instances where maybe a rogue prosecutor wanted to protect a particular defendant and agreed to a very lenient plea deal. In that situation, should a separate sovereign be barred from prosecuting for the offense or not? This case has also been discussed in the context of some of President Trump's recent pardons and what the scope of those would be. Is a pardon under federal law, would that also then bar a state prosecution for the same conduct? I'm not going to go out on as much of a limb as either Paul or David did in terms of making predictions.
Oh, come on, give it to, yeah.
But I will say that with this many relists and with potentially cross-cutting ideological sorts of concerns, if I had to predict, since David's goading me on, I don't think that the separate sovereigns exception is long for this world. But we'll see what happens with that. The second case I'll talk about is one that I'm arguing on October 10th. It's Air and Liquid Systems versus DeVries. Paul mentioned earlier that the court seems to be looking for cases that they can agree on. I also think the court is looking for cases that present really obscure, really interesting issues. DeVries, to me, fits into that category, and so does the next case I'll talk about after that, which involves the 21st Amendment. So the DeVries case involves products liability under maritime law. And I'm not kidding you when I tell you that people find maritime law interesting. When I've talked to some of the former Supreme Court clerks that we have here and mentioned that it's a maritime law case, their ears just perk up and they tell me how much they loved maritime law in law school and that all the clerks at the court would love a maritime law case. So the court granted this maritime law case even though it was just a 1-to-1 split. The basic issue in the case is whether a defendant is liable for failure to warn about a product that the defendant itself did not manufacture, sell, or distribute, but that is used with the defendant's product. So let me make that a little bit more concrete. The defendants in this case are government contractors who supplied equipment to the Navy for use in World War II. The Navy chose to use asbestos with the defendant's equipment. For all sorts of reasons at the time, asbestos was cheap, it was lightweight, it had a high heat resistance, and it served a lot of the Navy's purposes. The plaintiffs in the case are sailors who were injured by asbestos aboard Navy ships. The asbestos that injured them was not asbestos that the government contractors themselves supplied. Some of the defendants in the case didn't supply any asbestos at all. Other defendants supplied asbestos, but it had been replaced many times over before the plaintiffs were injured. And so the question is, in that situation, are the defendants liable for the injuries caused by somebody else's asbestos? The Third Circuit said they were, or at least they could be, because it was foreseeable that the asbestos would be used with their products. And it's true as far as it goes that it was foreseeable, but it's foreseeable that lots of products will be used with one another. It's foreseeable when a drywall manufacturer supplies drywall that it's going to be painted. That doesn't mean, as a matter of ordinary tort law, that the drywall manufacturer has to warn about the dangers of paint. It is foreseeable that a sushi knife is going to be used to cut raw fish. No court has held, as far as I know, that the sushi knife manufacturer has to warn about the dangers of eating sushi. So those are the sorts of arguments that we make on behalf of the defendants. The plaintiffs argue, nonetheless, that foreseeability is enough, and in fact that it was more than just foreseeable in this case, that this equipment really required asbestos in order to function. Why does this case matter? A couple of points I would emphasize. One, asbestos litigation continues to be a really big deal, both under maritime law against government contractors and in state courts across the country for non-maritime land-based asbestos claims. Because of the nature of asbestos-related diseases, they have such a long latency period. These claims are just coming up now, even though the conduct at issue occurred long ago. Second, it's not every day that the Supreme Court expounds upon Tort Law 101. And so even though this all arises under maritime law, one would expect that whatever the Supreme Court says about basic tort principles might also influence state courts in other tort cases, such as when the sushi knife manufacturer is inevitably sued. The last case I'll talk about briefly is one that was granted yesterday that I'll argue, I presume in January or February, although I'm not sure when that will be scheduled. A number of states have passed laws that require retailers and wholesalers of alcohol to live within the state for a certain period of time before they can get a liquor license. The question is whether those laws are protected by the 21st Amendment, which gives the states broad discretion to regulate the sale of alcohol within their borders, or whether those laws violate the Dormant Commerce Clause because they discriminate against out-of-state retailers who might not live in the state but want to come in and sell alcohol to the state's residents. This issue has produced a circuit split. It's also produced a number of interesting opinions from prominent appellate court judges. In the decision below that we're appealing, Judge Sutton dissented and wrote a very thoughtful opinion about both the history of the 21st Amendment and states' rights. On the other hand, Judge Calabresi in the Second Circuit has written a concurrence on a related issue saying that he finds the 21st Amendment to be a fascinating case study in the role of courts in updating anachronistic constitutional provisions. You can imagine that we featured that pretty prominently in our cert petition to try to get the justice's attention. So those are the three cases that I was asked to cover. Oh, sorry, that's Tennessee Wine and Spirits Association versus Byrd.
Well, thank you all. We will now have a rapid round, but I think since we started 5 or 10 minutes late, and if with David's indulgence, the speakers can stay an extra 5 or 10 minutes for your questions. But we do want to hear a little bit of whether our speakers have comments on the cases the others have presented, or any cases on the horizon. And I'm going to provide a brief comment on our Nick case because of something you mentioned in an earlier program. But since it's our case, I will also, and some of the litigation team that will be arguing it are here. The one minor correction is the ordinance that our client, Rose Nick, is challenging requires her to allow anyone, public or the city, 7 days a week during the daylight hours, though, so I won't exaggerate. But the interesting point that I think you commented on is that this will be the first case of the term that the Solicitor General, Noel Francisco, beloved here, former Jones Day partner, will be arguing for the United States. And I think you said, to your awareness or to your knowledge, it was the first time the Solicitor General has taken a property rights side on a takings case. But you don't, is that correct? Was that you, or am I misquoting?
I don't think that was me.
Okay.
I think that was one of my co-panelists.
Oh, your co-panelist. Okay. But I will now turn it over to you. And you mentioned one of the cases in an email, Paul, and this I will get correct, that you thought the Azar versus Alina case touched on Chevron land. So do you want to comment on that or any other cases?
Sure. So, well, one of the grants from yesterday was a case that, might not have jumped to the front pages of the news even on a normal day, but it was a case called Alina, and it's Azar against Alina, and it's Alex Azar in his capacity as Secretary of Health and Human Services, but he really inherits a long-running piece of litigation involving the reimbursement formulas for hospitals that provide services under Medicaid. And the formulas for this are mind-bogglingly complex, so much so that the secretary in an earlier iteration of this kind of messed up. And I think at this point in the litigation, it's more or less been established that the secretary kind of, sort of messed up to a degree. And the case really sort of concerns broadly when the government sort of makes a mistake and then tries to make a change to correct it, in their view. How do they have to go about that? Can they do it through adjudication, or do they have to go through notice and comment rulemaking? And there's an issue both that sort of applies generally in terms of the APA, but then there's also an issue that applies to this specific statute. So I think I've been involved in various stages of this litigation, earlier, so I have a certain amount of sympathy for anybody that's dealing with the Medicaid bureaucracy on these sort of things. But I do think, for those of you that are sort of less inherently interested and sympathetic to hospitals seeking reimbursement for their services from the federal government, I think the issue to watch here is that, this is a case where I think we'll learn something about what the justices think about notice and comment rulemaking, the administrative state, and all of that sort of implicates one of the $64,000 questions out there, which is, is the court on the verge of kind of a major reconsideration of Chevron? I don't think it'll come in this case, but I do think it'll provide some interesting insights about where the justices are on this. The only other thing I'll say in my little kind of lightning round here is just to say one other word about Gamble. I mean, one of the reasons I think that Gamble is very important is because we've talked about sort of three different cases where the court might overrule one of its precedents. And my own view is that, the Hyatt case is almost certainly going to be a 5-4 decision. I think, and if the court overrules its earlier decision, it will be with the conservative justices voting to overrule and the liberal justices saying don't overrule. I think Williamson County could well have a similar dynamic. Maybe not. I don't know. I don't think that one's as clear, but I think it could. And I think Gamble is, a case where it would be, I think, helpful for the court in the long run, frankly, if they don't overrule three cases by the same 5-4 margin with the same justices voting to overrule and the same justices sort of screaming about stare decisis. And I think Gamble is the one case where there's a possibly different dynamic. So I think it's an important case kind of to watch from that perspective in particular.
Williamson County was 80s. It was mid 80s, wasn't it?
Yeah.
Was it before Chief Justice Rehnquist became chief? Because there's sort of a dynamic here of reconsideration of the Burger Court. There are a number of these cases up that are questioning whether a Burger Court decision should be overruled. And I think maybe Williamson County was right there on the cusp. I could be wrong.
84, I'm looking to my, 85, okay.
85, so that would have
I
been
don't-
before.
Google.
Like the last year of the Burger Court.
Yeah. Anyway, just kind of an interesting factoid for cocktail party consideration.
So you're suggesting that the Burger Court, unlike fine wine, does not age well?
Well,
Is that...
there was a radicalness to the Burger Court that anyway.
So what other observations, comments, or cases on the horizon do you want to talk about?
Well, I would say that my only comment about one of Paul's cases, the Frank case, the Cypre case, is it arises in this context that's a little bit difficult, where you have an internet-based violation of a privacy principle, and you've got a gazillion potential violations, and you can't readily quantify the damages that each individual person sustains by virtue of that privacy violation. The question is, what do you do in terms of having a class effectuate an appropriate settlement with a company that has been found to have violated this act? And what, as I understand, I'm not immersed in this case at all, but I think that where the collision arises is there are a lot of very small dollar or cent violations where getting an expert to actually determine a model for expert damages allocations is quite complicated, and everybody wants to try to avoid that while everybody understands that each individual victim of the violation might only be able to prove damages in very low single-digit dollars. But when you aggregate them over many, many millions or hundreds of millions of people, it could potentially be a big money issue, but you can't figure out Paul gets a check for 98 cents and I get a check for 96 cents or whatever. I mean, that just is not practicable. And so, as I understand the way the Cypre doctrine works in these instances, is it provides a mechanism for there to be some compensatory function while sending money to entities that are designed to promote the purposes behind the act that was violated.
Although sometimes the plaintiff's lawyers or judges' alma maters. And so that's been one of the issues. Isn't that one of the issues that's arisen, at least in the lower courts, in the use of Cypre?
Yeah, I mean, I think in this particular case, that was a dimension or a fact, but there was also a privacy institute that had been set up at that law school that was geared toward the issue at hand. So, there's an atmospheric and an optic, and the question is whether that it drives how you should be viewing this when the company accepts the liability. So anyway.
Yeah, no, and David's right to sort of capture the dynamic in terms of, like in a case like this, just in the interest of full disclosure, you're probably almost all class members, since this really was like a privacy violation for using Google to search. So if you've done that, you're probably a class member. But if you do have a dynamic where everybody sort of stands to recover 98 cents, it also shows that the class members themselves aren't going to be able to really have any voice in this process. Even opting out of a class action like that doesn't make any sort of sense. And it does put a lot of pressure then on the courts when there's a settlement where the class action members aren't really in a position to have a meaningful voice, aren't even in a position to meaningfully opt out. Puts a lot of pressure on the court system to oversee that and ensure that the settlement is in fact fair. And that's why you do have and Ted Frank is the named plaintiff here, and he's sort of made a living out of sort of being the skunk at the proverbial garden party and coming into these cases where the class action lawyers definitely want to settle, the defendant definitely wants to settle, the court's in this awkward position in an adversarial system of justice of having the principal parties before it say, settle, this is fair, and having to then consider the objections that are brought to bear. So it's all just a difficult role, I think, for the Article III courts at the end of the day.
Yeah, there's an interesting irony here that a professional objector is the one who is complaining about that, where there's the alleged incest on the part of the various parties to try to get this worked out, where the professional objector is looking to get paid for having professionally objected to a class settlement.
In Ted's defense, though, he's different from some professional objectors in that he's sort of doing this a little more to shine a light on the whole thing in a little bit more of a sort of 501c3 capacity, as opposed to some of the other professional objectors who it's their business model. And for what it's worth, I mean, I do think there's that difference.
Shay, I'm surprised that Paul didn't object as we might if we file in your wine case for cheap wine. But since we didn't, what else do you want to draw to our attention?
So an interesting related question to what happens where you have class members who suffer only small damages is what happens when you have potential class members who actually haven't suffered any particular harm. And the case I'm thinking of is one that Paul's filed a cert petition in, and he didn't put me up to this, but it's a case for Zappos, and it has to do with data breaches, which, again, kind of like Google searches, we've all probably been subject to a data breach. Hopefully, few of us in this room have actually incurred any fraudulent charges or identity theft or anything else as a result of the data breach, but is just being subject to the data breach itself enough to give Article III standing. And Paul's petition, I think, makes a good case that not only is this the sort of issue that the court ought to take up, it's a really important question, but the courts are divided on it. So I think that's one case to watch. I also think we've been talking about a number of criminal cases. The court's criminal docket is going to be really interesting this term. And just to highlight a couple of those cases, one is Madison versus Alabama, and it has to do with whether it violates the Eighth Amendment to execute a prisoner who can't remember the offense at issue. This was one where both the Chief Justice and Justice Kennedy voted to stay the execution. It will be interesting to see now that Justice Kennedy is no longer on the court what role the chief plays in these sorts of cases, because Justice Kennedy was often the swing vote on Eighth Amendment cases. Another interesting Eighth Amendment case is Bucklew versus Preseith. I may be completely mispronouncing that name. That has to do with a prisoner who claims that using lethal injection would cause him unusual pain because of particular medical conditions that he suffers from. So it's not an across-the-board challenge to the lethal injection method of execution, but he's trying to challenge it in his case, and the state argues on the other side that it's mere speculation whether he would actually suffer any particular kind of pain or harm from this. And in fact, if the state were to execute him some other way, that might be even worse for him and for public confidence in executions, depending on how some other method of execution were to go. So I think these are interesting cases to watch with Justice Kennedy no longer on the court, because he's played a pivotal role on these issues in the past.
Thank you. Yes, in Buckley, if I remember correctly, he says the state is authorized to use the gas chambers. They don't have one. They've never done that.
Right.
So he's arguing they can build one and kill me that way. So, well, with that, I think I will turn it back to David.
Well, thank you. I'm very upset that I learned that I'm not going to receive adequate compensation for my privacy breaches at the hands of Google. So here's how we're going to do this. We're going to have questions. I'm going to ask you to please ask a question. Please ask it concisely. And we're going to, I'm going to ask the first question, take a point of privilege to ask the first question, because a certain word came up that for those of us who are socially stunted conservative legal nerds is particularly upsetting, and that word is Chevron. Some of us know Chevron as a gas station. Many of us know Chevron as the beating heart of the administrative beast. And there's this weird world there's this very strange Twitter world that's arisen of fan communities around justices who pick particular legal issues as their hobby horses. And there's this Justice Gorsuch fan community around his hatred of Chevron. And what I would like to hear from a panel of practitioners who study the court probably closer than almost anyone is Chevron actually under threat, or is this going to be sort of the hobby horse of a small minority of the Supreme Court?
Well, I'll just say that it depends on what you mean and you think Chevron is. So Chevron, I think, was the most cited case in the federal courts through 2016, something like that. And it had been cited in a huge number of Supreme Court cases. But the question of whether Chevron was actually followed was studied by several legal scholars who determined that Chevron might be invoked, but it wasn't actually followed in a very large number of cases that were decided by the Supreme Court, and the court would rely on other cases instead. And so I think that, it's the "it depends" answer depends on exactly what aspect of Chevron you think is at issue and whether or not the court has already decided hundreds of cases that have relied on a different administrative law principle that arguably would not be consistent with the holding of the Chevron case itself, or would be suggestive of a different rule. For sure, justices, and Justice Gorsuch is certainly the prime example, have led to question the actual Chevron case holding itself. But I think you could probably cite any number of cases that already have questioned aspects of the Chevron doctrine as it would be applied in a number of administrative law settings.
To audience members who aren't nerd lawyers, Chevron is the court's practice of deferring to agencies' interpretation, particularly of law. And it itself has a two-part test, and then there are these doctrines that David mentions in which the justices will not defer. And I think someone observed there were 5 cases where the Supreme Court focused on Chevron last year, and in all 5 cases, they did not apply judicial deference. I think that's a trend. Do the others of you agree? Whether it sort of supports your point, I think, David, that there's a difference between invoking Chevron and applying judicial deference.
And I'll just sort of jump in here and really, I think, I mean this to echo what David said. He may not think it does, but I think, sort of revisiting Chevron is a little bit different from revisiting sort of Williamson County or revisiting sort of the Hall against Nevada case, where it's a methodology, and it's a case that prescribed a methodology. So it's not as simple as you overrule Chevron and then results change radically the next day. And if I could suggest just an analogy, when I was sort of starting my legal practice, one of the kind of most interesting issues in religious liberty law was whether the Supreme Court would overrule the Lemon case. And having sort of now litigated religious liberty cases off and on for 20 years, I kind of come to the view that it really doesn't matter whether they overrule the Lemon case, because they just sort of ignore it half the time, now more than half the time, and they occasionally invoke it when it's convenient for them to do it. But what really matters is not how often they're invoking the Lemon principle or citing the case, but how they actually decide the specific cases about religious liberty that are before them. And I think with respect to Chevron, we may see something similar, which is they may not squarely overrule Chevron. They may, but they may not have to either. And we may just see a pattern emerge, and Todd's suggesting that it may have already emerged, but we just may see a pattern emerge that in a variety of different ways, the court is just less deferential to the positions that are embodied in agency regulations and is just a little more interested in what the text of the statute says. But even that's difficult. I mean, the Gundy case will show you that if you look past the regulations to the statute, there's no there there. And that's really what started the Chevron issue in the first place.
Yeah, everybody in Gundy, this is the sex offender registration provision, agrees that it's an unambiguous statutory provision. It just doesn't say anything. I mean, substance, it doesn't have any substance to it, but no one argues that it's ambiguous, which is when you'd ordinarily invoke Chevron to have the agency expert interpretation of the statute. No, I agree completely with Paul, but I think that the reason why it's so much more complicated is because over time, different agencies have developed different practices for creating law conferring or law principles. Sometimes they're revenue rulings, sometimes they're advisory letters, sometimes they're decisions by boards, sometimes they are actual regulations pursuant to notice and comment rulemaking. And so you've got this menagerie of different tools that administrative agencies use to impose their will or to exercise their power pursuant to statutes that may or may not be quite so clear in conferring that authority. And that's where the whole Chevron cluster of problems and issues arises. It's as diverse as does the Solicitor General writing an amicus brief on behalf of an agency entitled to get a deference for the views expressed in that amicus brief, which the government has successfully asserted in the Auer case. And things like that, where the invocations of deference are quite broad and across a vast spectrum, that's where I think the skepticism of Chevron comes in, because agencies are going to want to defend what they do, and they're looking at Chevron as the basic umbrella idea to get that authority.
The other point I'd add to this, David mentioned in posing the question that it seems like there is a conservative following for Justice Gorsuch's skepticism of Chevron. Chevron itself, as initially conceived, can be thought of as very much a jurisprudentially conservative doctrine, because it's about deferring to the elected branches in order to fill in the gaps in the law, rather than having courts themselves make law. I think that pendulum has now swung as agencies have taken the liberties that Chevron might give them farther than some might like. I think more conservative judges have become more skeptical of Chevron. But it's interesting to remember that Chevron actually started out from the other perspective.
And in the Reagan administration.
All right, well, as per tradition, I'm going to ask first if there's any questions from the professional press who are here. Yes, ma'am? And wait for a microphone, please.
Is it on? Thank you. I'm Peggy Orchowski. I'm the congressional reporter for the Hispanic Outlook. And everyone's concerned about affirmative action. And I know that that Kennedy was a swing vote on that. So I don't know if you've discussed that yet, or is there any indications that might come up as an issue?
I don't think there's anything currently on the docket, but there certainly are cases involving university admissions practices that are percolating their way up. There are cases involving university admissions practices that are percolating their way up that are likely to get into the Supreme Court, including Harvard. I think the University of North Carolina is another case where there's active litigation on that issue.
So as you know, this is not a priority.
I'm not aware of any case currently on the docket that raises an affirmative action question, but that's not to say there aren't cases in the courts of appeals that might be decided and cert petitions filed in the next few months. I don't know.
All right, this gentleman here.
Yeah, good afternoon. I was wondering if anybody, speaking of cases on the horizon, would be in a position to comment or forecast the ConAgra and Sherwin-Williams California-led litigation. I think it's the cert petition's not been considered yet. I was wondering if you could either prognosticate that, or if it goes on the docket, what might happen.
Sure. I mean, I'll be happy to take that one since, I filed, there's two cert petitions in the case, one filed on behalf of ConAgra and NL, which, I'm the counsel of record on, and then Sherwin-Williams, represented by Jones Day, has also filed a petition. So I would say the forces of thinking that would be a great case for the Supreme Court to take are well represented on our panel. Notwithstanding, David may not have a dog in this.
And we filed an amicus brief in support.
Yeah.
So
Yeah,
3-0, I think.
So the issue, just for those of you that aren't as familiar with the case as at least I am, this is a case involving a quite novel effort by the state of California to use public nuisance law to go after sort of corporations in a way that kind of solved most of the problems that were perceived by plaintiffs' lawyers in suing the lead paint industry. So, lead paint litigation has been around for some 3 or 4 decades at this point, at least. But there were a number of efforts to litigate against the lead paint sort of companies, some of whom are like ConAgra, are really sort of are companies that inherited a prior company or were a distributor as opposed to the manufacturer. But there were all these efforts to sue, and most of them ultimately kind of foundered on concerns about proving sort of causation, and how do you prove that any one defendant is responsible for the lead paint, say, in your residence. And so the lawyers involved in this case sort of got around that by trying to label lead paint in residences to be a public nuisance. And then under California tort law, their theory was, so we don't have to really prove anything like causation or anything like that. And then to make it even more interesting, they also sort of said that one of the principal bases of liability isn't even the manufacturer of lead paint, but it's actually the promotion of lead paint for indoor residential use, which for most of us lawyers, when we hear that you're being hundreds of millions of dollars of liability is being imposed on promotion, this little sort of hairs in the back of our neck go up, and we think, maybe there's a First Amendment issue there. And so, they're both due process and First Amendment issues with what California has done in sort of allowing its public nuisance law to facilitate this, massive lawsuit with a recovery that approaches $1 billion in a context where, some of the companies' only promotional activity took place decades ago, if not a century ago, and you also have the fact that it's sort of conceded that there's no reliance that's been proved, and causation is something that, at least in a normal sense, they don't even have to prove. And you could at first blush think, wow, that's bummer to be a lead paint company, but why does that concern anybody else? But I think if this works in this industry, there's nothing particularly specific about this kind of use of the public nuisance doctrine, and you're already seeing the public nuisance doctrine being used in a lot of other contexts, the most prominent one being opioid litigation. And you do have this kind of brave new world of litigation where the principal plaintiffs are municipalities or state governments, and their principal sort of litigation theory is public nuisance law. And the extent to which there are going to be any federal limits on that kind of state litigation, I think is front and center in these petitions, and I think it's tremendously important. It's not the kind of cert petition where 3 federal circuits have addressed an obscure issue of federal law one way, and 3 other circuits have addressed the same obscure provision in a different way that neatly presents itself as a cert petition. But my own entirely biased view is this is frankly a lot more important than a lot of cases that have that character, because this is something that if states can litigate in this way, can allow this kind of litigation without any constraint for either the First Amendment or the Due Process Clause, I mean, I think a brave new world will be unleashed.
One procedural point to add to that: this case was originally scheduled for the conference this past Monday. It was one of several cases that the court rescheduled for a later conference. They don't explain why they do that, but at a minimum, that suggests that somebody's already taking a close look at this case, and maybe it's a case they're waiting to have a 9th justice before they decide whether to grant cert.
All right, yes, ma'am, over here.
I'm Heather Gradison, former chairman of the Interstate Commerce Commission during Reagan 1, 2, and Bush 1. Back to Chevron. What purpose does it serve to have independent agencies if the court is going to weigh their decisions? With an independent agency making a decision, wouldn't the parties just ignore whatever the independent agency does and take it to the court?
Well, I mean, a couple of things. I mean, there might be 1 or 2 justices that would stop your question at what's the point of having independent agencies? Full stop. So I think one of the reasons this issue is important is because it's a little bit of a stalking horse, and that may be the thrust of your question. It's a little bit of a stalking horse for broader questions about reconsidering the administrative state. And in that sense, I think it's similar to other cases like the Free Enterprise Fund case, where the court was dealing with sort of dual levels of removal protections, but they were also that may have been a stalking horse for broader questions about whether you ought to have that kind of insulation from presidential control at all. So I think those issues are going to be in the backdrop, no matter how no matter exactly which case tees this up. And to echo what I said earlier, I think where the justices ultimately stand on those broader questions may have more to do with how they resolve cases, and maybe more important in the long run than precisely what they think about Chevron. I do think, though, there still may be a role, certainly for those cases where independent agencies engage in more of an adjudicative function, for that to be deferred to, even in a world where the statutory interpretation questions that are squarely teed up in Chevron are somewhat either reconsidered or retooled a little bit. I mean, I think there may be still a role in when you're in more of an adjudicative function than just a rulemaking function.
Yes, ma'am, right here.
My name is Elaine Middleman, attorney, and I talked to Shay about this. I have to say, since I'm sitting at Jones Day, I was a summer associate at Jones Day 1979, which is this famous summer that Crowell and Mooring was in the same location as Jones Day. Anyway, Joe Sims wrote he gave a speech and he wrote an article about double jeopardy and dual sovereignty. for the ABA convention. I was the one that just did the heavy lifting of the law books, but that was 1979, so I think you need to give him credit for how many years ahead of time was he. That was good. And my basic question is trying to understand the incorporation doctrine. If you take Heller, what if there hadn't been incorporation under McDonald? Would you have a different standard for constitutional rights in D.C., where it'd be the First, Second, Fifth, whatever amendment, and not in the states?
So you would, and I was actually directly involved in the McDonald litigation, and at the time I sort of thought of it as as this incredible opportunity to be involved in the court's last incorporation case. But it turns out I was wrong, and there's still one or two other loose threads. It's not clear that the bail clause has been incorporated by the Supreme Court itself. But yeah, I think that the issue in an incorporation case is basically whether or not a provision of the Bill of Rights is only going to constrain the federal government, or whether it's going to constrain state and local governments as well through the operation of some provision of the 14th Amendment. And there's no question that if the court were to say that a particular provision was not incorporated, that would leave you into a situation where constitutional rights were different in the District of Columbia and in federal court from state court. The incorporation doctrine, I should also note, just to marry up the two halves of your question, is also lurking in the background of the Gamble case, because at the time that the court first started thinking about the separate sovereign doctrine, you didn't have full incorporation of the double jeopardy clause, and so in a world where the double jeopardy clause only constrained the federal governments and the federal courts, there was at least an argument for why the separate sovereign doctrine makes some sense. In a post-incorporation world, it makes, I think, less sense, and in pointing to the changes in the law that might justify reconsideration of precedent, that's one of the important arguments that the petitioners make in the Gamble case for why the separate sovereigns doctrine should be reconsidered.
All right, last question. The hand that went up real quickly over there. Wait for a microphone, please.
Hi, my name's Dan Albin. I'm from the Institute for Justice. I wanted to ask about the Weyerhaeuser case that'll be argued next week. And I know primarily the case is about the Endangered Species Act and the interpretation of terms like habitat related to a particular species of frog. But I know there's a sort of secondary issue in the case that relates to the Administrative Procedure Act and judicial review. And I was wondering if any of the panelists or Todd could comment on the likelihood that the court will address that sort of secondary argument and potentially open up agency inaction to judicial review.
I'll say one thing, and then maybe Todd can bring us home unless somebody else has something to say about it. I think just to focus on one thing you said in your question, this is going to be argued next week, and so there's a good chance it's going to be argued to 8 justices, and so I guess that would suggest to me that maybe the court is going to look for some very narrow way to decide the case, and so I'm not sure they're going to sort of reach sort of broader issues or go out of their way to decide anything more than they have to in the case. But
well, Dan, thanks for asking the question. First of all, I will not say too much about Weyerhaeuser, although our counsel afterward in the row near you will tell you. But there was a wonderful dissent from the panel opinion, and then a dissent from denial of en banc from a judge I used to clerk for. And I think there are several other ways that the court can resolve the decision in our client's favor. But I will tell you all that the petition to watch is the one that my colleague Jonathan on the issue you mentioned that Jonathan Wood filed, and it's the California Sea Urchin Commission case. And there, this gets back to your trigger word, Chevron. The Ninth Circuit extended the Chevron deference. So even if David and Paul are right, and I would have thought they were right, that the court might be still shy about overturning it, what we're asking the court to do is, in that Sea Urchin case, is to at least stop the Ninth Circuit's extension. And the Ninth Circuit's interpretation, I won't, again, talk to Jonathan or me afterward about it. The Ninth Circuit said that, well, the statute was silent, and we're going to provide Chevron deference to the fact that Congress did not prohibit the agency to do what it wanted to do. We believe that is a extension, and it is an unworkable. How do you apply whether it's reasonable or not for the agency to engage in activity that Congress didn't prohibit? So the state of Texas and 16 other states, so 17 states supported us, and we have some other amici, but the state of Texas said that the court should grant the petition and use it as the vehicle to overturn Chevron as its alternative argument. The easier would be to at least stop extensions of Chevron. So David, you can write about that one too.
Please send it my way. Well, thank you all for coming. Thanks to Pacific Legal Foundation, National Review Institute, and Jones Day, and the panelists, of course.